Yes. Now, the strikes and lockout also under the present Industrial Disputes Act, there is some confusion which is legal lockout, etc. But the simple thumb rule is illegal. You take it from me. That's the simplest way to look at it. In non-public service, everything is legal. Certain conditions are there, no doubt, but it's all fine. But therefore, in a strike and lockout, what is legal, what is illegal, etc., is always a difference is there. And what is a public to service? If a notification is given, whether my industry comes under the notification or not, itself is a matter for interpretation. So it was a bit legalistic issue. And now this present code has made it very difficult, either public utility service or no public utility service. Now everything is an industry, that's all. Therefore, they have to give definitely 14 days notice in whatever industry they are functioning. Therefore, it is made very stringent. Now, strike also now by definition includes a situation where 50% of the workers go on a casual leave in a concerted manner. That is also not a mass leave, or I have a casual leave to my credit, therefore I go on a strike. So strike is made very difficult, and in the same way, the lockout is also made very difficult. So strikes and lockout hereafter should not be done the drop of the hat, or a wildcat strike, etc., will be facing stringent action. Therefore, this is a good thing where industrial peace is sought to be maintained by the provision of law. Yes, next. This issue, why this provision was brought at all? In 1947, it was not there. It was brought in 1976. It was struck down by the Supreme Court in Excelvar case. Then in 82, it was introduced. It was challenged. It was upheld. If you read the 1992 1LLJ of Workman of Meenakshi Mill case, 5 judges have held it's valid. Some of the reasons given by them, like the retrenchment, closure, layoff will lead to large-scale unemployment, misery to the workman in these days of unemployment, poverty, etc., was said in 1982 when the section was introduced, 1992 when the judgment was given. In 2020, it is not the situation. If someone says I'm unemployed, he is the laziest person in this country. And the business scenario in 82 and 92 is not there now. Now, the companies have to be very nimble, and unless they keep pace with the trend, they will simply extinguish from the scene. Therefore, this continued rigid approach to layoff, retrenchment, and the closure of the establishment, increasing from 100 to 300, may bring some cheer, but it is not at all good. The employers are matured enough to employ the workmen. We don't employ the workmen to lay them, retrench, or close our industry. We have invested to run the industry. So give me that leverage. I'll tell you in 1 minute a classic case which took place very recently. An export garment company which only to USA because of this COVID lost their orders, or they were asked not to ship. Now, the standing order provided for layoff due to pandemic. The application is filed. Is this ground to reject layoff? Therefore, my anguish is, why should this provision be still in statutory book? Next, because I now only next. Interim relief. See, one good highlight is the industrial unemployment is pending before the tribunals for a longer period. anywhere between 1 year to 4 or 5 years. Therefore, now a provision has been brought that during the pendency of the dispute, interim relief by the court's order during the pendency of a litigation before the labor court. This is a good height to be looked into.